All right, if you're just joining us, welcome. We will be starting the webinar on Israel-Palestine and the ICC in just a moment. Just sit tight as we let people into our Zoom room. We'll be starting very shortly. Again, if you're here for the webinar on Israel-Palestine and the ICC, you're in the right place. We are just allowing people to enter our Zoom room, and then we will be getting started in about 30 seconds. All right, I'm going to go in and get started. There are still people joining us. They just may miss the introduction. Good morning and welcome. I'm Lara Friedman. I'm the president of the Foundation for Middle East Peace. I'm very happy to welcome you to our webinar today, Israel-Palestine at the International Criminal Court, What's Next? Background. On February 5th, 2021, the pre-trial Chamber 1 of the International Criminal Court, ICC, found that, and I'm going to quote, the court's territorial jurisdiction in the situation in Palestine, a state party to the ICC Rome Statute, extends to the territories occupied by Israel since 1967, namely Gaza and the West Bank, including East Jerusalem. So this ruling, which was explained by the ICC itself in a link that my colleague is going to put into the chat box now, this ruling opens the door for investigations into alleged war crimes perpetrated by, again, quoting, quote, members of the Israeli Defense Forces, Israeli authorities, Hamas, and Palestinian armed groups. So today's webinar is a follow-up to the ICC-focused webinar the Foundation for Middle East Peace convened last year, April 2020, in the context of the ICC's then ongoing consideration of opening a formal probe into Israel and Palestinian actions in the occupied territories. That webinar, which attracted nearly 1,000 viewers in real time, and which has been viewed nearly 1,000 times since, is a terrific primer if you want to understand the ICC and Israel-Palestine and sort of the fundamentals, and I encourage people to watch it. I think my colleague is going to put a link to that in the chat as well. So if you really enjoy this one, you should, and you haven't seen that, go back and watch that one too. So today's panelists, some of whom are repeats from the last webinar, in alphabetical order, I'm going to name them and describe them. You can read their full bios on our website. So we're very honored today to have with us. Oh, by the way, if you're squeaking in the background, I have a puppy, so just ignore it. So our first panelist, first on our list is alphabetically, Katherine Gallagher. Katherine, or Katie, is a senior staff attorney at the Center for Constitutional Rights and has represented victims before the ICC, including persecution by Israeli officials in the situation of Palestine. Prior to joining CCR, she worked at the International Criminal Tribunal for the former Yugoslavia from 2001 to 2006. Next, we have Hassan Jabareen, who is the founder of Adalah, the Legal Center for Arab Minority Rights in Israel, serving as Adalah's general and legal director since its establishment in 1996. Hassan has litigated scores of landmark constitutional law cases regarding Palestinian citizens of Israel, including the Palestinian leadership, and international humanitarian law cases concerning Palestinians in the 1967 occupied territories before the Israeli Supreme Court. Next, we have Dr. Michael Kearney. Michael is a legal researcher with Al-Haq, the Palestinian human rights organization, and lectured on human rights and international law at the University of York, LSE, and University of Sussex. And last but not least, we have Yael Stein. Yael is the research director at B'Tselem, Israeli human rights organization. She has authored several B'Tselem reports, including a report called The Occupation's Fig Leaf in 2016, Getting Off Scot-Free 2017, and Fake Justice 2019. And she co-authored B'Tselem's most recent report entitled This is Apartheid. So Before we get started, quick housekeeping. As is our normal practice, the format for today's webinar is going to be a moderated Q&A, a conversation between me and the panelists, and maybe a little bit between the panelists and each other. In addition to my questions, we welcome questions from the audience. Please submit them at any time during the Q&A and put them in the Q&A box in the Zoom window. Do not put them in the chat box. I won't be watching the chat box, but I will be watching the Q&A box. And also, please note this is being recorded and live streamed on Facebook. If you have technical problems, let my colleagues know using the chat box, and keep an eye on the chat box because there will be resources being posted throughout the webinar that go along with what people are saying. So that'll be a great resource. And all those resources will be posted online with the video afterwards, so you can come back to them. So last thing I'm going to note, this webinar is an hour-and-a-half long. So we have 4 amazing panelists, all experts in their field. I've asked them to keep their answers as succinct as possible so we can cover as much ground as possible. And we're all going to do our best at that. So let's just jump right into it. So Michael, I want to start with you. Al-Haq and other Palestinian human rights groups have welcomed the February 5th decision of the ICC's pretrial chamber. And I want to read from the press release. They called it, quote, a critically important step towards ensuring the rule of law, and a, quote, decision that marks an important step towards ending impunity while ensuring the dignity of the Palestinian people who have been denied their right of self-determination and subjected to the criminal regime of apartheid, forced displacement, transfer of nationals to the occupying power, extensive destruction and appropriation of property, pillage, willful killings, persecution, among other crimes within the jurisdiction of court. So, can you talk about why Palestinian human rights defenders view this decision as so important, so consequential?
Thanks, Lara. I'm going to try and kind of answer that by reference to 3 points. I think in the first instance, what the decision and the potential investigation into the situation in Palestine by the International Criminal Court, essentially what it promises is the application of the rule of law to Israel's military occupation of Palestine. What we've seen over the decades since the occupation began in 1967 is that the Israeli state and the Israeli military has not lived up to its obligations and has not respected its obligations under international humanitarian law and under international human rights law. Neither has the international community, by which I mean other states and the United Nations and so on, neither have they lived up to their obligations to ensure that Israel operates within the international legal framework. So what we've seen, what we've experienced is that in the absence of rule of law and in the absence of accountability, the occupation has been characterized by widespread human rights abuses, many of which are severe enough to be characterized as international crimes. So I think the kind of key promise that the International Criminal Court presents is challenging that situation by bringing the rule of law to bear and by holding people accountable for their actions. Second point, a kind of more general point, but equally important. Essentially what the chamber has decided and affirmed is that the occupied Palestinian territory is Palestinian. Now, they're not breaking new ground here. This is the position of the United Nations General Assembly, of the position of the International Court of Justice, the position of the vast majority of states. But it's an important one nonetheless to essentially affirm that Israel does not have title or sovereignty over the occupied territory. It's critically important given that over the past year, during 2020, we've seen Israel, supported by the United States, take steps towards attempting to officially annex more Palestinian territory. So for the chamber to reaffirm that the occupied territory is Palestinian and that is rooted in the Palestinian right to self-determination is important. And finally, and briefly, what we've seen from states, including Germany and Canada over the past year or so, they've engaged with the process before the International Criminal Court, and they've requested that the court refrain from engaging in Palestine. They deny the existence of a Palestinian state, and more politically, they reject, essentially they're rejecting the application of the rule of law to Palestine, and they're arguing that the conflict and the occupation can only be resolved through political negotiations. Now, those political negotiations in the past have been very heavily skewed in favor of Israel, given the power dynamics. Political negotiations have in the past ignored, or essentially ignored, international law and ignored the rights of Palestinians. What this decision has put in train is it essentially makes law, it confirms that law exists alongside politics, and that if states are in good faith want to contribute to resolution of the conflict and resolution of the occupation, they can no longer reject the fact that international law must apply alongside political processes. So there would be the kind of 3 points I'd sum up with.
Thank you. That's a great way to start this off. Hassan, I want to move over to you, and I want you to talk about one of the really hot issues in this debate, which is the question of jurisdiction. Adalah published a report a few months ago rebutting the Israeli Attorney General's argument that the ICC doesn't have jurisdiction over the case. They argued that because Palestine is not a sovereign state and Israel has legitimate claims over the territory, there's no jurisdiction. And Adalah wrote, or you wrote, the Attorney General's claims are irrelevant to the purpose of the Rome Statute, which determines charges for criminal wrongdoing of persons and not states, and does not determine claims of sovereignty. So, can you talk to us, those of us who are not international lawyers, about how we should understand the ICC ruling on jurisdiction? And what does the court have jurisdiction over? And how does it relate to the question of sovereignty when it comes to the occupied Palestinian territories? And you are muted, Hassan.
Good morning for all of you, and good evening to Haifa. We have a different time. This decision of the ICC is very historical and presidential decision in Israel-Palestine conflict. There are many UN resolutions since '47 that directly refer to the Palestinian question. And even we have one of the most important international court decision, the ICJ, that give expert opinion on the legality of the wall. But the decision of the ICC now indicate that this is the first time that matters that refer to the occupation are also matter of trial, matter that can be before a court, international court. The ICJ give, as we know, expert opinion, but here the case is different. Second, also this decision of the ICC cut the new debate that a Trump administration with Netanyahu government started to put that there is no occupation, there is disputed area, West Bank, Gaza, and even Jerusalem out of the table. This decision said, yes, there is occupation, West Bank, Gaza, and Jerusalem, and this is the basis of the discussion. So this end also the attempt of Netanyahu government and the Trump administration to create a new discourse regarding the status of the Palestinian occupied territories. Regarding the position of the Attorney General of Israel. This is also the first time that the Attorney General of Israel is engaged in international case that questions the legality of Israeli occupation. As we know, on the ICJ case, Israel boycotted totally the hearing, and the AG wasn't ready even to issue any statement, legal analysis before the decision itself of the ICJ. This time, the Israeli Attorney General issued his report, his opinion, his expert opinion regarding the question of jurisdiction. Yes, he didn't submit it before the ICC court, but it was reported in order to be submitted, meaning like to be in and to feel without the process. This shows that also the Attorney General of Israel is aware about the significance of this decision of the ICC. Now, his argument based on the question of sovereignty. There is sovereign state, which called the State of Israel. The State of Israel controls the West Bank, Gaza, and Jerusalem. There is nothing called Palestinian state. There is no sovereign Palestinian state. Thus, this case cannot be brought before the ICC, as the ICC can deal with cases between states. The argument that there is a Palestinian state is a fiction. Second, the intervention of the ICC in this case will be intervening on Israel sovereignty, internal matters of sovereignty. As the Attorney General indicates that we have claimed over Jerusalem. We perceive Jerusalem as part of Israel. We perceive the West Bank also as part of the historical land of the Jewish people. Thus, any intervention will intervene also on our claims. We have claims. This is the first time, in fact, that the AG does say clearly that he or his office doesn't recognize the status of West Bank as occupied territories. Israeli Supreme Court always put different status of West Bank. West Bank and Gaza are not Israel. Jerusalem, yes, part of Israel. Here, the Attorney General took a new step. The other claim that he raised, that any intervention also will be as intervention on Oslo Accords between Israel and the PLO. And thus, in the end, he argued that if the ICC exercise its jurisdiction, it must enter political question. It's not legal question. Our report face those arguments. Our privilege also that we know the Israel law and we know the Israeli Supreme Court decisions. So also we refer to the contradiction between the Attorney General position that was submitted before the ICC and his legal position before Israeli Supreme Court. But we emphasize that his concept of sovereignty is very old concept. This concept was valid until the Second World War. After that, this concept was changed. Today, the concept of sovereignty by itself cannot stand without the question of responsibility. And here, the AG didn't indicate any, or he didn't provide any answer regarding the question of war crime that the prosecutor raised. He just referred to technical issues that has nothing to do with the jurisdiction of the ICC. The ICC doesn't deal with question of borders. ICC doesn't deal with political claims between the PLO and Israel. Any decision of the ICC has nothing to do with any future agreement between the PLO and Israel. The only thing that the ICC will deal is with the right of population. And this is the shift that happened in IHL, that IHL transfer the question of sovereignty, the classical question of sovereignty, to a question of protecting the population, emphasize and centralize the issue of protecting the population. And thus we argue that all what the AG raised are irrelevant to the question of jurisdiction. The ICC can trial Israel because and without dealing with all the issues that the AG raised, because in the end the jurisdiction is against personnels, whether they committed or were responsible for war crimes or not. We are happy that the decision of the ICC also emphasized this matter, that the jurisdiction of ICC has nothing to do with the questions of sovereignty of any state, but to the rights of population. And here also the question of impunity, as Michael raised, is a matter.
Thank you. And you also addressed, there are a couple questions in the Q&A box about Oslo, so thank you for addressing that as well. You took care of those very efficiently. Katie, I want to come to you. You represent Palestinians who are pressing the ICC to investigate crimes Israelis have allegedly committed against them. In response to the February 5 decision, you tweeted, and I follow you on Twitter, I recommend everyone does. You tweeted, "Today's decision is because of the decades-long work by Palestinians at home and abroad who have continued to struggle for recognition of their right to self-determination, which the ICC explicitly endorses, against tremendous odds and pressures." So there's a lot of discussion about the politics of the ICC, the legal, sort of technicalities. Can you talk about what the struggle is, the Palestinians who are bringing these cases? And can you talk about, given the odds and tremendous odds and pressures, what you see, how they see the ICC as a court of last resorts at which they're seeking justice?
Sure. Well, good morning, everyone, and thank you so much for inviting me to participate today. And I am here as a legal representative for Palestinian victims in the ICC proceedings. I'm certainly not a proxy for them, but I am here as their legal, in the capacity of a legal representative. And that tweet, I think there are so many politics, and I would like to be able to separate those. There are so many politics around this, and so much time and energy in the week since the decision has gone into what will the Biden administration do, or what will Netanyahu do, and that is infuriating, frankly. I would like to see the attention placed on why it is that the ICC is actually moving to open an investigation in Palestine, and that is because of decades-long cycles of impunity, of crimes of the most serious nature, crimes against humanity and war crimes committed against Palestinian civilians. I have the privilege to represent Palestinian victims from Gaza, the West Bank, including East Jerusalem, as well as the diaspora, and pressing for an investigation that indeed looks at the war crimes, that some of which have already been flagged, war crimes related to the settlement enterprise, war crimes related to the military assault on Gaza in 2014, war crimes related to the pillage of natural resources, Palestinian natural resources. And I would suggest also the ICC must open investigations into crimes against humanity. These are crimes that have as their target a civilian population. It's a widespread or systematic attack against a civilian population with a practice or policy behind it. And when we look at whether it's the settlement enterprise or the ongoing closure of Gaza and the denial of fundamental rights to Palestinians writ large, rights like the right to family unity, right to movement, right to life, right to livelihood, right to health. We see that certainly in this moment with COVID, but it's pre-existed the COVID moment with a decimated infrastructure and lack of access to medical care. So the crime against humanity of persecution is one, a frame that the victims I represent have pressed for the ICC to adopt, to really look at these practices and policies of Israeli officials at the highest level. I think it's important to dispel, some of the rhetoric around who will be the target of investigations. It will not be low-level foot soldiers, and it will also not be the state as the state. It will be those who bear the greatest responsibility for war crimes and crimes against humanity. I would suggest that is military officials, civilian leadership, those who have crafted and who enforce policies of discrimination, land grab, death, torture in prisons. These are the kinds of serious crimes that need to be investigated. So the way this case got to the ICC is victims for decades coming forward and telling their stories, whether to Palestinian human rights organizations, including organizations like Al-Haq, organizations like PCHR, Palestinian Center for Human Rights, and Al-Mizan, which have documented and collected evidence about crimes over many, many years, so that there are in fact case files that can be turned over. It's the work of researchers, including at B'Tselem, the work that Adalah has done, exposing why it is that Israel is simply unable and unwilling. Well, it's able if it wanted to, but it's unwilling to hold its own accountable. And these are some of the questions that I suspect will come at the next stages, whether Israel has conducted any kind of investigations. I would suggest when we have policies and practices such as the settlement enterprises or a military assault on Gaza like we saw in 2014, where civilians were in fact either the direct target or over 51 days, the indirect target of those indiscriminate attacks, that these are not the things that Israel has ever investigated, and it's unwilling to investigate them because these are ongoing crimes.
Thank you. I'm sorry, did you have more? I didn't mean to cut you off.
I just wanted to add one other point. I wrote in that tweet about the odds that Palestinian civil society and victims have faced, and there is tremendous pressure on Palestinian victims, civil society and human rights organizations, and indeed the PA, to not pursue justice and accountability. Victims have been discouraged in overt and covert ways. Palestinian human rights organizations have been named quote unquote terrorists for pursuing justice and accountability. The Palestinian Authority has had threats, and now we've seen cutting off of funding if it pursues justice at the International Criminal Court. So this is not an easy road to get to the ICC and to get to that decision on February 5th.
Thank you. And you mentioned a lot of things we're going to get into, I hope, later on in this conversation. I think it's really important, really, that you're here. And, I'm in the Washington bubble. And when we talk about this, it really talks about in political terms, right? What it means to Israel, what the battle means for the United States, or it's all in political terms. The debate almost never actually addresses what the underlying case is about and the actual victims. of policies on the ground. And I think it's just incredibly important to remind people of that, bring them back to, it's like having a discussion about immigration reform without actually talking about what's happening to people who are family separated or deported or whatever in the United States. So thank you very much for that. Yael, I want to come to you now, and I want to build more on that court of last resort piece of it. The ICC, as I understand it, is supposed to act only when the state fails to investigate. That's the argument. You bring it in. Israel, of course, insists that it does investigate alleged violations of law by its own soldiers in the occupied territories. And your organization, B'Tselem, which has been tracking human rights and the behavior of forces for years, has a different view. Specifically, I know in 2016, I remember this was a big deal at the time, B'Tselem stopped referring complaints to the military law enforcement system. And it was explained in one of the reports that you authored, which was called, the report called The Occupation's Fig Leaf, which I think is going to be thrown up into the box, the chat box. In that report, you argued, and I'm going to quote, there is no longer any point in pursuing justice and defending human rights by working with a system whose real function is measured by its ability to continue to successfully cover up unlawful acts and protect perpetrators. So can you, we'll get more into some of the details and I hope the next question. For now though, can you talk about what the military investigation system looks like? And what does Israel mean when it says it holds its forces accountable? And what is your view of Israel's ability, or as Katie just said, willingness more, to hold itself accountable?
Well, maybe I'll start with the bottom line. Israel is not willing to investigate any crimes committed by her security service in the occupied territories. Now, it has this very sophisticated law enforcement system, long paper trail, dozens of people working on the investigations, getting decisions, discussions in the High Court and any other courts. But it's like a paper towel. I mean, the minute it's very easy to see that it's only a facade. It's not a system that is intending to bring about any meaningful accountability for those people who are actually responsible for the committing of the crimes. Now, the main problem is the fact that this system, by definition, is not even dealing with policy questions. They only deal with the soldiers on the ground and people who are actually responsible for designing the policy, or the legal advisors that are behind these policies that actually said this is what the soldiers should do, that actually legalize all of the crimes. There's not even a place for them to be investigated. It's not part of the legal system, the legal investigating system. It's not part of any system. So even if somebody wants to bring and demand the investigation of the high, very top levels officials, there's no way to go. Now, it's the minute that they define it by definition, I mean, they define the role of this system very, very limited to the soldiers on the ground. So it has no connection to what the ICC is supposed to do. The ICC, as was said before, is looking at the top officials that are designing the policy and are responsible for enforcing the policy. Now, you can see the problem, for example, I mean, one example to see how the system is not working by definition is that the fact that the MAG office, the military attorney general, he's supposed to decide which cases are to be investigated, but he's also the one who legalizes the policies in advance. So if he said that a policy is legal, how can he investigate himself? So by definition, we can see that it was not even designed to investigate any policy level. And it's clear, I mean, if we look, for example, at the situation of protective edge, what happened during protective edge, that Israel claimed that it investigated it and that it had the whole mechanism designed to investigate it. Now, in practice, what Israel did is investigating very specific cases of targeting houses that people were in them, died because of the bombing. And this investigative system only checked those very specific cases out, not looking even at the policy that allowed to bomb houses with people inside them. This policy was never questioned. The only thing, the specific pilot that put the specific trigger. And it's the same if we look at what happened with the demonstration in Gaza now, that started 3 years ago. The policy was allowed to shoot at unarmed demonstrators that didn't pose any danger to the soldiers. And the policy actually allowed snipers to shoot them. More than 200 people were killed. The policy was taken to the High Court, and the High Court said the policy is legal. So if the policy is legal, the High Court said it's legal. So of course that when the army is coming to investigate it, it will not even look at the policy level. It will not look at the military attorney general who actually said, okay, that's fine. He will not investigate himself. So when Israel is saying, I'm investigating, they investigate the soldiers, the very low soldiers on the ground that actually were implementing the policies, even if it were legal or legal, this question never even asked. And if we go through some of the investigative cases, we can see that it's almost ridiculous, because if they only ask the soldiers, did you obey this specific order? And nobody even think about asking whether the orders themselves were legal, or the investigation doesn't even adhere this policy. So in this kind of system, there is no way to get real accountability and real justice. And one last point, the demand for accountability, and I'm following what Katie said before, the demand for accountability is not a procedural demand. It's not something theoretical that we lawyers sit here and demand from our houses that this will happen. It's important for the victims. It is needed for the victim to get the justice on these specific cases. And without this accountability procedure, it will never happen. Now, the real investigations and efficient investigation, it's not only for the victims themselves, but it's also to stop future victims. Because if soldiers will know that they will have to pay price for that, and that maybe they will, I don't know, maybe will have to go to jail even, maybe they will think twice to do it. But it doesn't work like that. So we don't get justice for the victims. We don't get any deterrent for future cases. And this is why we need the ICC. This is why the ICC is the last resort.
Thank you. The word impunity, I think, is going to come up a lot throughout this webinar. Yael, I want to stay with you for a minute. Bringing up one of the arguments we all hear when we're discussing this, I think. B'Tselem talks about in some of its writing about Israel giving blanket immunity to its security services. It's sort of what you're referring to. You don't look at the actual policies, and you are very narrow in what you investigate. But there are cases where soldiers have been prosecuted for crimes. There's a very famous case, Lara Azaria, who was he served 9 months in prison. This is a soldier who basically executed a Palestinian who was on the ground, clearly no longer a threat, and it was on video. I mean, he was probably prosecuted because there was a video. The officer who killed an autistic Palestinian man, Al-Haq, in the old city of Jerusalem, looks like he may be charged with manslaughter. So how do you contextualize these in that analysis? I mean, do these show that the system can work? Are these exceptions that prove the rule that it doesn't work? What do they mean?
Well, I think those cases prove what I just said. I mean, they are very few cases. The fact that we remember them and that you can mention them so easily, it's because they're so few. And they are there to maintain the facade. I mean, Israel is smart. I mean, if there will be 0 cases going to courts, 0 cases that soldiers had to pay a price or had to do something, everybody can call Israel bluff. It will be very easy. So they need to so-called sacrifice every once in a while a soldier. Usually it will be cases that they don't really have choices because the video was all around the world, or very severe cases, but not always. And even on these cases, the punishment will be very low. They will be charged with in most of the cases, they will be charged with almost insignificant offenses. Like we have one case from the demonstrations in Gaza that the soldier was tried for not obeying an order. I mean, he killed somebody and he was charged with not obeying an order, which, I mean, he didn't obey the order, but that's not the issue. And I think that this is what we can see how the system works, is that taking very specific cases, looking only on rare cases, actually opening an investigation. I mean, as I said, they do not investigate policies. They do investigate specific cases, but even that they don't really do very seriously. Most of the investigations are almost negligent. Really, they're not even trying to show that they are looking for the truth. There is hardly any attempt to get real evidence, outside evidence, and the only thing that they are actually bothering to take is testimonies from soldiers, which also they get some problems to get those testimonies. And basically they believe whatever the soldiers will say. What is weird that there's something that is almost not talked about, but Palestinians cannot file complaints with Israel, with any Israeli authorities about something that happened to them. I mean, it's very, very sophisticated, very complicated for them to succeed to file this complaint. Usually they will do it through Israeli lawyers or human rights organizations. It's not open. It's not really clear. If you want information from the investigative system, it's almost impossible to get them. You need to remind them again and again. So it's not really, there's no real access for justice for the Palestinians victims. Now, all this, I mean, the fact that this system of investigation is not working, it's not by chance. I mean, it is the policy, the Israeli policy, because if it will work, if soldiers will have to pay price for the violence that they inflict on Palestinians, they won't do it. If they won't do it, the occupation will have to end, because you can't hold the occupation without any violence. So it is, I mean, it's a way to continue the occupation, to make sure the occupation is ongoing and Israel can maintain whatever aims it wants through the soldiers who secretly are being promised you won't have to pay anything.
I find myself thinking, as you're talking about how the system works, of Michal Sfard's book, A Wall in the Gate, where he interviews one of the former heads of the civil administration, I think, who thanks the human rights groups for helping them figure out what they have to do to give cover to do exactly what they want in the West Bank, just exactly what little things they need to do, in a sense, navigating the complaints of human rights organizations. It's probably the single most depressing anecdote in that entire book in my mind.
And this is why we stopped, just one more sentence, I mean, this is why we stopped sending letters to the Israeli authorities, demanding investigation, because we do not want to be part of it and legitimize the system by sending the letters. And then they can say, well, you see, we are investigating, tell them send us a letter, we open an investigation. Now we know that they will not investigate. So we thought it's better, well, we're not part of the game.
Thank you. Hassan, Yael has referred to events in Gaza. I want to shift the focus a little to Gaza. And I will say in the international community, certainly in the United States, there's not a ton of focus on Gaza. It mainly is on the West Bank. But Adalah talks about Gaza as a legal, I'm going to quote you, a legal black hole where, quote, a vacuum is created which provides a wide space of impunity that allows for the killing of Palestinians without any legal responsibility. And that's what Yael was just referring to. You call on the ICC to investigate Gaza in defense of the victims there. What is this legal black hole, and why is it important for the question of jurisdiction and for the investigations going forward? You're still on mute.
To make it easy for the participants and the listener of us, a black hole case is the case that knows no legality. For example, that everybody knows, or at least I suppose that many of our participants now know, Guantanamo case in the beginning. Guantanamo case, the US State Department declared that the American Constitution won't apply there. The question came whether the law of war will apply there. They say also the law of war won't apply there, not IHL, not American law. So which law? There is no law there. This is the case of black hole. When you create a situation that you don't have legality, there is no legitimate legal system that apply there. Without legality, there is no responsibility. Without responsibility, you will create impunity. Why you create impunity? Because there is no legality, there is no one will be charged and responsible. So this is what Israel made Gaza. Israel made Gaza as black hole. How Israel made Gaza as black hole? In 2007, Israel made distinction between the status of Gaza and the status of West Bank. They said that, and this was a decision of Israel government, the security cabinet, that declared that Gaza is enemy entity. Now, what's that mean, enemy entity? Enemy entity means that you have to treat Gaza as enemy, including every person who lives there will be enemy alien. And we know this doctrine after 9/11, what that's mean, enemy alien. Enemy alien is the person that doesn't enjoy neither constitutional protection and not IHL protection. By this, Israel law provide that even if a person will be injured illegally, meaning what's illegal here in this situation in Gaza, you cannot even use the term legal or illegal because there is no something called law in order to know, to make the distinction between what's legal and what illegal. But any person who will be injured by shooting by Israeli forces, he won't have access to Israeli court. He won't have effective remedy. Why? Because he is an enemy alien. And if Israel use any forces in Gaza, this won't lead to any responsibility. This is why on the Supreme Court case that Yael mentioned regarding the march on Gaza in 2018, 217 protesters were killed. None of them was armed. And 19,000 persons were injured. Israel used snipers. And Israel Supreme Court admitted that, in fact, none of those, almost none of those, was armed. Despite that, the Supreme Court dismissed our petition to order the army to stop using snipers, to stop killing people, especially when we are speaking about unarmed and peaceful demonstration, civilian demonstration. So what was the reasoning of the court to get out of this question? It was easy. Every soldier in a Gaza field has full discretion to use the arm. We are not going to tell any soldier when to open fire and when not to open fire, because Gaza is enemy. And with enemy, you are not putting legality and rules in advance. This is the black hole. Now, to your question, what's the connection between this matter and the question of jurisdiction of ICC? Israel Attorney General argued that we are the sovereign state over Gaza. We answer sovereignty comes with responsibility. But if you are the sovereign, and we can respect that, so you have to respect the IHL. Your law doesn't respect IHL. You created black hole. Now, this is the responsibility of the ICC to prohibit creating a black hole. One of the reasons of establishing the ICC is to end impunity. And in this case, this is the responsibility of the three judges of the pre-trial to decide on the case, in the meaning to decide that there is a jurisdiction, because they cannot ignore the question of impunity. If the ICC ignores the question of impunity, it ignores the raison d'etat of its establishment. This is the connection between black hole, sovereignty, and jurisdiction of the ICC. This is why we believe in Adalah, that knowing how the Israeli Supreme Court decides the cases of Gaza, it's very important to the continuation of the case before the ICC. Otherwise, it will be like position of the AG, and you cannot confront it. So those decisions can bring the facts and what the Israel law say exactly about the case of Gaza. And about what Yael said, which that Salem had a really important decision not to cooperate and to stop to submit complaints to the MAG, because as Yael explained, that it wasn't efficient and needless to do that and just give legitimacy. I can say even if you cooperate, you won't give legitimacy, because Israel law created a black hole, make a Gaza black hole. Even if you continue to submit complaints, they will dismiss those complaints. This is what happened to us and to Al-Mizan, the Palestinian human rights organization in Gaza, that we submitted many complaints to the MAG about cases in Gaza, and all of them were dismissed. Today, we received the response of the Israeli Attorney General on the case of Bakr, case that we submitted before the Supreme Court, because the MAG closed the file, and we said Israel must open a criminal investigation for the killing of the boys in that incident. And again, we receive a response that show that illegality is the rule of law on Gaza, meaning that Israel doesn't perceive itself as responsible of dealing with those cases. To take responsibility is the negating of impunity. Here with Israel, put the impunity first, that's meaning that there is no responsibility. So even if you continue, you will prove again and again that there is a legal black hole.
Thank you. That's incredibly helpful for understanding Gaza. I appreciate that very much. Michael, I want to come back to you, and I want to hone in on another key issue that's coming up. Al-Haq has called on the ICC to investigate Israeli settlement activity, and that is reportedly one of the elements of an investigation that the state of Israel is most worried about, because it would expose a large number of Israeli lawmakers and leaders to investigation and really the fundamental policies underlying the occupation and de facto annexation. So first, can you explain what are the alleged crimes related to settlements, and what are the ramifications for Israel if there is an investigation and prosecution specifically related to the settlement enterprise?
Okay. I mean, the type of activity and conduct that makes up the settlement enterprise is quite distinct from what we've just heard in relation to the Israeli military and attacks on Palestinians in Gaza. When we talk about the application of international humanitarian law, everything can be contested and everything can be challenged, especially when it comes to official militaries and in their combat or their attacks against civilian populations. The war crimes related to the settlement enterprise are completely different, in my opinion. It seems to me that the fundamental war crime of the prohibition of the transfer of civilians as settlers into occupied territory appears to be the closest that international criminal law comes to having a crime of like strict liability, in the sense that there doesn't seem to be any justification or defense by which the Israeli state or Israeli lawyers can contest such charges. Now, the crimes, like the rhetoric from the International Criminal Court over the last 2 decades of its existence has been to, and quite rightly, has been to emphasize its role in combating atrocity and atrocity crimes. Now, while that's correct, the kind of spectacular violence of atrocity isn't the only type of conduct that the Rome Statute was designed to confront. So aside from like physical violence against a person, international law, including the International Criminal Court and international criminal law, is also directed against the structural violence of colonialism and of annexation. And this is what we see in the prohibitions of settlement. Now, since the Geneva Conventions of 1949, international law has explicitly prohibited as unlawful the transfer of civilians into occupied territory. The logic to this prohibition is that international law accepts and tolerates occupation as an inevitable consequence of war, of armed conflict. But it tolerates occupation on the basis that it's a temporary phase of a conflict. In order to ensure that occupation is temporary, we have the prohibition on the transfer of civilians into occupied territory. And the idea being that when a military occupier brings its own civilians into occupied territory, then we're flipping from a temporary occupation to a permanent colonial construct. What we see in the West Bank is, and the war crimes applicable to the settlement enterprise. In the first instance, to construct the settlement, you have to seize property. That requires seizure and destruction of Palestinian property to construct the settlement itself and the infrastructure like roads and so on that goes with it. So that is an unlawful appropriation and destruction of property that constitutes a war crime. In confiscating property, in destroying Palestinian homes, you're displacing people. There's no legal justification for that displacement. It constitutes crimes of forcible transfer and unlawful displacement. And then when you bring your own civilians in to live in the settlements, which is probably the kind of key war crime here. This is the transfer of your own civilians into occupied territory. So you basically have kind of 3 interrelated war crimes: the unlawful seizure and destruction of property, the unlawful displacement of Palestinians, and then the unlawful transferring of Israeli settlers. I mean, the effect of the settlement project in legal terms is both to deny Palestinian self-determination, to prevent it from being exercised, but also in the distinct, focusing simply or merely now on the occupied territory. It's the distinction between how the Israeli state and the military occupation treats the settler population and how it treats the Palestinian population. And that discriminatory treatment is that's the basis for the charge of apartheid as a crime against humanity. So the ramifications and why I expect the Israeli, lawmakers and politicians are concerned with the International Criminal Court investigating settlement enterprise is that back in 1998, when Israel took part in the negotiations that created the Rome Statute, it voted against the adoption of the statute, and it gave the reason that it disagreed with the inclusion of the war crime of transfer of civilians into occupied territory. So I think it's a significant one because it goes to the heart of the conflict as one of territorial acquisition. And as a criminal lawyer, it simply doesn't, I simply don't see how, if any Israeli politician is charged with this war crime, I can't imagine what type of reasonable defense they can make for their case.
Thank you. And that's actually a really good lead into my next question for Katie. And after this, I have 2 more rounds of questions, including some from the audience after this question to Katie. So I am going to beg all of you, everything you're saying is they're gems, they're gold, but if there's any way to have shorter answers, otherwise we're gonna not have very many more questions. So Katie, given all the alleged crimes that have been laid out, both by Michael now and in previous rounds or previous answers, what would the potential charges against Israeli soldiers or lawmakers be? And what could the potential legal repercussions be for them?
Sure, and I think a lot has been said that I don't need to repeat, but I just want to highlight a couple of quick points in getting to that answer, Lara. One is the way we're talking about Gaza and the West Bank, including East Jerusalem. And I just want to emphasize that that is a fragmentation that is intentional and is part and parcel of Israeli policy and approach towards Palestine and Palestinians. And some of the victims that I represent have the fact that they cannot travel from one part of Palestine to another and be with family members in another part of Palestine, seek education in another part of Palestine. This is part of the entire, in my opinion, criminal enterprise, and why the crime of persecution, in addition to what Michael said about apartheid, is such an appropriate frame by which to look at the holistic picture, the macro level. And it's the International Criminal Court that is built with the crimes that it has to look at that kind of high level. So in terms of the specific question of sort of what we expect to see, the prosecutor has been carrying out a preliminary examination for 5 years. When she moved forward to say, I'm at the point of finding that there's a basis to open an investigation, and I just like confirmation, and I think it's important to remember what that February 5th decision was, confirmation that the territorial scope of the state of Palestine included Gaza, West Bank, and East Jerusalem. And because Palestine acceded to the Rome Statute, the treaty setting up the International Criminal Court, that is why the prosecutor can exercise jurisdiction. I'm just trying to answer some of the questions about why it is that, let's say, Yemen isn't before the ICC, but Afghanistan is, because Afghanistan, like Palestine, is a state party. And so Israelis are before the ICC, not because Israel is ceded, but because the territory of Palestine is now before the ICC. And that's also why US soldiers and actors are before the ICC in the Afghanistan torture investigation. But here, what I expect we'll see, based on what she already indicated in her preliminary examination report, is settlement enterprise, is pillage, is the 2014 military assault, is the 2018 Great March of Return attacks. And I hope it is looking at things maybe more holistically than even those specific sections. And as we've moved from preliminary examination and hopefully are going into this investigative stage, the prosecutor has a whole other set of tools at her disposal. So that would mean for any of the 123 member states of the ICC, they can get requests for information. They have to cooperate with the prosecutor and send information. And this can be in the form of communiques or information that they have about Israel's actions on Palestinian territory. We will certainly have victims putting forward a significant amount of factual information and legal analysis to help frame and deepen the legal analysis and the factual crime-based evidence, and help explain to the prosecutor, either the current or the incoming, the array of information that already exists against particular actors. And I would say that, again, that includes Israeli civilian and military officials, that we will help point out the policies, the statements, the actions, but it's not only those actors. It could be corporate actors, not corporations themselves, but individuals who are benefiting from and helping to further the settlement enterprise and some of the military operations. So I think where exactly the investigation goes, and it can go in many stages, we're looking at something that could be quite sweeping, and really work through the many stages of what Michael said is a colonialist enterprise.
Fantastic. I'm guessing we have time for one more round. I have more questions on that, but I'm gonna pick and choose a little bit because I think we probably have time for one more round. So Katie, I'm gonna stay with you now. There are a number of questions in the box, and I have a question for you about the US and the US role. And I specifically want to ask you about the executive order, which is a legacy of the Trump era, putting sanctions on Fatou Bensouda, the ICC prosecutor. That has not been lifted yet. I think a lot of people thought it would have been. It hasn't been. There's news today from, I think, Barak Ravid breaking the news that Bibi has asked the US not to lift the sanctions. They want those to be leveraged to corner the ICC. Can you talk about those sanctions, the idea of the US using sanctions against the ICC, and looking again in the Q&A box, there's lots of questions about what you expect the US to do, and you know, potentially what could be helpful or what will they do to be unhelpful?
Sure. And this goes back to your first question to me about my tweet and the tremendous pressure. That pressure was also on the court. That pressure has been on Fatou Bensouda, the current prosecutor of the ICC, and her office, not to get to the stage that we're at. Those pressures have been, again, in the form of financial pressures on the court itself over the years, with member states maybe as acting as proxies for the United States or Israel in cutting the budget for investigations or keeping it low to make it more difficult for the prosecutor to reach the stage of moving towards investigation. So there are soft and kind of hard pieces of pressure that have been exerted over the many years. But the most shocking, and really the word is shocking, was the June executive order out of the Trump administration. And this followed years of threats, years of pressure. That pressure and those threats really grew during the Trump administration, with John Bolton and Secretary of State Mike Pompeo really taking the lead in saying that if the International Criminal Court, the prosecutor, moved forward towards investigations in either the situation of Afghanistan, including looking at US torture, or in the situation of Palestine, which includes, but is of course not limited to, looking at Israeli actors, the US would take unilateral steps up to and including sanctions, and threaten sanctions against the court, against judges, against the prosecutor. And there have been efforts by civil society using UN mechanisms to try and say this is an attack on the independence of the court, on the independence of the judiciary. There were many warnings about just what the US was planning to do, but ultimately the Trump administration did not respond to maybe efforts by others to call off taking such severe steps as an executive order with the sanctions. And in June 2020, after the authorization of the investigation into Afghanistan, and after the prosecutor said, I'm at the stage of wanting to move forward towards an investigation into Palestine, Donald Trump issued an executive order, and it has two parts. The first part allows for the designation for sanctions of individuals, non-US citizens who do acts that the United States declared a national emergency. Now, it's somewhat undefined what that is, but it's related to the investigations of US actors in the Afghanistan situation and of allies, which Israel was explicitly named. And then it has a second part, which can, under a US statute called IEPA, can provide civil or criminal penalties for those who provide assistance to anyone who has been designated for sanctions. And those civil and criminal penalties could also apply to US citizens. So at the time this came out in June, we saw former US military, former US government officials, bar associations at home and abroad, legal experts, academics, civil society groups condemn this, UN officials condemn this executive order and really describe it as a frontal attack on the rule of law and the independence of the judiciary. It was somewhat in step with what we saw with the Trump administration of obstructing justice. And maybe that forestalled what we ultimately did see in the beginning of October, which was the naming of Fatou Bensouda and one of her senior staffers as designees of sanctions. So they are currently and remain on a sanctions list. And because of those civil and criminal penalties of anyone who gives any kind of support to a designated person, whether you're a bank, that has nothing to do with ICC investigations, or whether you are, let's say, a lawyer or a victim who wants to provide information to the prosecutor, you face the threat of criminal or civil sanctions. So this has had a profound chilling effect on the ICC, on civil society, on the legal and the legal community. There are two lawsuits. The Open Society Justice Initiative led one, and there has already been a preliminary injunction against enforcing the executive order against those named plaintiffs because it interferes with their First Amendment rights. And so we were all expecting the Biden-Harris administration, an administration that includes two lawyers, and of course, Kamala Harris was a prosecutor herself, to rescind this executive order. And now here we are more than a month into the administration, and it's still on the books, and Fatou Bensouda remains on the sanctions list. That does not necessarily mean that we will not see engagement with the ICC, but this is a threat that exists out there, and I think it is a sign that we can't take what the Biden administration is saying about its priorities at face value. It has said human rights are a priority. It has said it wants to return to the international community and respect the international legal order. But it right now would prosecute and sanction those who want to pursue justice and accountability for crimes against humanity and war crimes.
Thanks, Katie. That was amazing. Guys, we have 18 minutes left and there's 3 more of you. I want to give you each one more question. I'm urging you to stay 5 minutes or under, otherwise you're all not gonna be able to talk. So Yael, I want to come back to you, and this is a good follow-up for Katie. What do you expect in the coming months and years if the ICC investigation moves forward, and particularly the immediate implications for Israel and its reaction? And here I want to reference reports that there is draft legislation that's going to be introduced in the Knesset that mimics the legislation that Katie just referred to in terms of criminalizing cooperation with the ICC by Israelis or Israeli organizations. And you have 5 minutes, go, or less.
Well, it's too soon to know what will happen and what effect this decision by the ICC will have on Israel. It's clear that Israel is almost hysterical, calling everybody anti-Semitism, that the decision is a reflection of anti-Semitism, citing the Holocaust, citing the persecution of Jews 2,000 years ago. I think Israel just can't believe that for the first time, it will have to pay a price for its activities. That's the meaning of the decision. Now, of course, we do not know what will happen. It's too soon to know. It might help. I mean, like we see on the one hand that Israel wanted to deport the Khan el-Ahmar community next to Jerusalem, and then the Bensouda said that will be a war crime, and they didn't deport them, although they are still can do that. But on the other hand, Israel is deporting other communities and demolishing other houses in the West Bank, and continuing the siege on Gaza and its policies in East Jerusalem. I mean, it's not that Israel said, okay, now we'll stop everything because of the ICC. So it's really too soon to know, and we will believe anything when it will happen. Now, one word about the international community that Israelis keep saying, why are you talking to the international community? Why are you demanding the international community to do to affect Israel's policy? Now, this is exactly what Israel is doing now. It's already demanded from Biden to make sure that the ICC won't investigate it, approach Germany to file the amicus when it was appropriate, and now to say that it does not acknowledge the decision the new decision by the court. So Israel is using the international community whenever it's helpful. But the international community now has a crucial role on two levels. One is that it has to save the ICC prestige. I mean, the ICC is under an amazing, hateful attacks by Israel and its allies, saying it's political, decision is not legal, it is, etc., etc. I think the international community has a huge role here in defending the international community and the values that it's supposed to protect. Israel is using the Holocaust to say, well, you can't actually sue us now in this court, but it's exactly the opposite. The ICC is supposed to protect exactly to make sure that things like the Holocaust won't happen again. And Israel is very cynicism about that. I think the international community also has a role in continuing pushing Israel to abide by its obligation under international law and to make sure that justice is done. And the ICC is not the only place. It can go to the Security Council, it can affect the bilateral agreements, but the international community is not done because the ICC said that an investigation can be opened, and they just reminding that it didn't open yet. We are in a very, very preliminary stage. We do not know when investigation will be open, if it will be open. So we are in a low expectation now.
Thank you.
In less than 5 minutes.
That's perfect. Thank you. Hassan, I want to come back to you. I want to talk about Palestinian citizens of Israel. So the ICC decision has nothing to do with them. It's about the occupied territories in the letter of it. That's how people are reading it. Do you see any possibility that the ICC may actually refer to Palestinian citizens of Israel as they are part of the Palestinian people? Or will the investigation have any other impact on the status of Palestinian citizens of Israel? Or are they completely perceived as within what is the understanding of Israeli sovereignty? And you have 5 minutes, go. And you are muted still. I'm not going to use that against you.
This is a great question, and maybe your very, very difficult question that you put for us now. In one hand, yes, the Palestinian citizen refer to the internal sovereignty of Israel, and they live in the Green Line, and there is no jurisdiction of the ICC over the Green Line because Israel is not part of the ICC, didn't sign the treaty, and they are not under occupation. On the other hand, if the ICC will investigate questions that refer to the Palestinian people, some of those questions also are common question to the Palestinian people. For example, Israel may argue about the settlement. That doesn't mean that the existence of the settlement is permanent. we have never declared internationally that it's permanent. And there is no intention maybe to show that. So here you have the Jewish nation state law that apply also to East Jerusalem and show that in fact the intention of Israel is to apply its constitutional identity over the Palestinian without the Palestinian agreement. And then maybe this will open the discussion about the consequences of this constitutional law, how this law can improve a question of intention uh, and uh, and also the objectives of Israel, because constitution all the time lay the vision of the state. So here the vision of the state can come through the Jewish nation state law. At the same time, the Jewish nation state law apply to the Palestinian who live in the Green Line. So can the ICC neglect this question and refer only to the part of the Palestinian people who live under this law beyond the Green Line, and the other who live in the Green Line will be neglected? This is a question, legal question. Another matter might raise, there are many common things between common actions, Israeli actions against the Palestinians in the Green Line and Palestinians beyond the Green Line. For example, home demolitions, for example, displacement. Take, for example, the case of al-Hiran, unrecognized village that the Supreme Court legitimized its evacuation and displacement in order to build a Jewish settlement. You have many cases in the West Bank like that. So suppose that the ICC will say that what Israel did, for example, for Khan al-Ahmar cases in the West Bank constitute war crime. So if this is the case, why not al-Hiran in the Green Line is not war crime? So maybe the ICC won't deal with that. But we as a lawyer, we have a new tool. If I stand before Israeli Supreme Court, I can say what is happening in the Naqab, in the Negev, in south of Israel, in the Green Line against the Palestinian Bedouin. The ICC already said that those activities that done against the Palestinian Bedouin in Hebron constitute war crime. So here we are speaking about war crime. This will help us in international advocacy. This will articulate a new legal language for us as a human rights lawyer who deal also with Palestinian citizens of Israel. So there is dynamic, because you are speaking about the same state, Israel, and the same people and similar actions and similar crimes or similar atrocities from the state. So if the ICC will proceed, I think it will change the terminology, the rhetoric, the discourse of the human rights lawyering community who deals also with the Palestinian citizen of Israel. Of course, our friends from B'Tselem will love that, because their report about one regime, one apartheid, all the Palestinian people live under one regime. So I expect that our legal imagination will be different than our current legal imagination.
Thank you. Thank you very much. It's very provocative as a point. And you know, it's striking how much Israel has worked to erase the Green Line in so many ways over the past 53 years, and that in some ways comes back to haunt them at this point. Michael, I want to come to you. And this is something Yael, I think, referred to a little bit. Looking ahead, we're going to see a new ICC prosecutor taking over. This is someone named Karim Khan, who has been painted in various media reporting as potentially more sympathetic to the Israeli position. Can you talk about how you see this leadership change in the ICC and what it may mean for this case? And also, can you talk a little more, and Yael and Katie both have referred to it, about the role the Biden administration and Europe are playing in seeking to dissuade the ICC from taking up this case, or from moving forward with this case, I should say.
Okay. With respect to new prosecutor, you know, I've noticed various speculation as to his leaning one direction or another, but I've not seen anything that's anyway compelling in that regard. So I don't really have a strong opinion on that. I've no reason to doubt his bona fide when it comes to this investigation or anything else. To be honest, I mean, what the prosecutor, I mean, obviously a leader is important, but the office of the prosecutor is always about more than one person, and it's about a team. So I mean, what the court needs, what the prosecutor's office needs, and this isn't simply to do with Palestine, but much broader. It needs resources and it needs cooperation from states. And these are two things that are, you know, significantly lacking, which may kind of be highlighted possibly by the kind of political fallout around an investigation into Palestine. What we would love to see from the current prosecutor right now, or as soon as possible, is an announcement of the opening of a formal investigation into Palestine. When the pretrial chamber handed down its decision a few weeks ago, it kind of justified giving its opinion in that decision on the basis that they implicitly understood an investigation was already underway. But we kind of need to see that confirmed. With regards the US, you know, just to give one example, because there's a danger here of thinking and assuming that you know, the US under the Biden presidency re-engaging with international institutions is automatically a good thing. When what we see yesterday at the Human Rights Council in Geneva is the United States you know, turns up in Geneva and expresses its intention to rejoin the Human Rights Council and sets out its mandate and so on. But it's doing so on the condition that Palestine is removed from the permanent agenda of the Human Rights Council. So, you know, it's great to think that, you know, the United States is going to engage internationally, but we have to be cautious as to what are the conditions on which the United States is basing that that engagement. And finally, you know, we see it in how Canada, Australia, Germany, how these Western liberal states reacted to the decision of the pretrial chamber to say we don't accept the existence of the state of Palestine, and you know, how those states are going to cooperate with the court in the future is going to be very significant in that institution and in the kind of the development of the broader framework of international law. Thank you.
Thank you. And I'm actually going to use my power as the moderator to impose a lightning round. We have a lot of questions in the Q&A box that go along the lines of, well, what can we do to help? What can be done? I want to give each of you one sentence to answer that, maybe two sentences, but not long sentence, because that is obviously that there's keen interest in what can be done from the outside to help. And if you don't have an answer, you don't have to give one. But I'm going to start with Yael, you're first.
Well, that's a good question. I think the most important thing is to talk about it, to disperse the information about it. It's kind of not on the agenda of any country now. You know, Corona, COVID, etc., etc. Now it's the time to push your own governments to make sure that the investigation is open and that Israel is changing its policies.
Thank you. Hassan, you're next.
We see that how politics can affect the international law. The first international criminal law was created in Nuremberg trials by the Allies, and due to their victory and this trial succeeded to develop the international law and to reach the establishment of ICC. Now, the same power, the empire, the only empire in the world, US, may damage this achievement if they put sanctions on the ICC. If they put sanctions on the ICC, and this will lead to limit the work of the ICC. In this case, in fact, we can speak about the end of legitimacy of the ICC in other cases. This is why it's very important, I think, to lobby and to speak about the importance of the ICC, and also to try all the civil society, all the activists in the US to criticize any position from the US which put barrier to the exercising of the international rule of law in this case. So to speak about it is very, very important. I will urge all the leading universities in the law schools in the US or law students to start to have sessions about that, to start to speak what that means, that put sanction on the most important court on the world. That was the achievement of Nuremberg trial. And by this to create a new discourse.
Thank you. Powerful answers so far. Michael, you're up.
Sorry, I'm not going to give particular suggestions as to advocacy, but what I would like to point to is one thing that kind of unites the situation in Palestine, and this is aside now from the International Criminal Court, but which kind of aligns the situation in Palestine with a far more global struggle for justice, can be seen in the rollout of vaccines against COVID-19. So what we've seen in Palestine is, and this is why we talk about apartheid, is where vaccines are being rolled out on a nationality basis, where Israelis are being provided with a vaccine, Palestinians in occupied territory are not. And someone mentioned earlier, sorry, I forget who, about corporate responsibility and corporate complicity. 2 days ago in the Financial Times, they ran a story on Moderna as the vaccine firm, and we've got comments here from the chief executive of Moderna, responding to how Israel is taking its extra stock and exporting it to its allies in Europe and America, rather than providing Palestinians with the vaccine. So that would be my kind of suggestion, is it's not simply Israel and Palestine exclusively. We're all part of a broader society on this.
Thank you. And Katie, you get the last word.
Great. Well, all excellent points before mine. I'd say take some time to read about why the ICC is so important and who it is important to, and that is for Palestinian civilians and victims. Understand what they have been suffering, that this is about them first and foremost. It's not about politics, but it is about ending a cycle of violence and oppression against Palestinians in every aspect of their life. That has been going on for years and years, and at least the ICC can look back to 2014, and doing so will help realize Palestinian self-determination and liberation. And that is something that I am pleased that the International Criminal Court framed its decision as one about self-determination and the importance of ending impunity. And so for the audience out there, spend some time following the victims' stories as they come forward in additional submissions, the human rights reports that are coming out from Palestinian human rights organizations, and try and get the news to talk more about the Palestinians themselves, the victims, the survivors, than just about the politics.
Wonderful. Thank you so much. We're going to end here. On behalf of the Foundation for Middle East Peace, I want to thank Katie, Yael, Hassan, and Michael for participating in this webinar, which was amazing. I always say this, but truly, I wish we could go on another hour. Thanks to everyone who joined us in the audience, especially those who submitted questions. If your question did not get asked, don't worry. We're going to give them in writing the entire list of questions to our panelists to inform them as they do their own thinking and speaking and writing going forward. Check back on the Foundation for Middle East Peace website for recording of this webinar and for links to everything that was put into the chat box, and also to sign up for other webinars and resources. And a quick shout out for our next webinar, which is this coming Tuesday. It is about the movie Till Kingdom Come, Evangelicals, Israel-Palestine, and Messianic Politics. And I guarantee it's going to be a lot of fun. And with that, we will sign off for today. Thank you all so very much.
Thank you. Thank you.